And thank you for joining us on the third, I think, King's Chambers Course of Protection Q&A webinar. I'm Richard Borrett, as you can hopefully see from on the screen. You can also see I'm joined by Sophie Hurst. We're both members of the Course of Protection team, and we are going to be endeavouring to answer your questions which you have helpfully sent in. We had quite a lot of questions for this afternoon. We know that we're not going to be able to cover all of them. Certainly a couple that came in today, both of us have been in court and we haven't had a chance to look at, but they will be hopefully held off for another one of these sessions. And there was a couple of questions that were rather broader than could be covered in this sort of session, so that we're going to have a look at those and speak to those people about what we can do to answer those in more detail. But so sorry if we don't get to your question. So the first question we have is a question about Ferreira. That's how I pronounce it. Whether I'm pronouncing it right or not, I don't know. It's a Dole's case. And the question was, how has the decision in Ferreira impacted on the application of Doles in care home settings for residents with prolonged disorders of consciousness? Would a standard authorization still be required? I think in order to answer that, I'm going to go back to what Ferreira was really about. The person in Ferreira, well, first of all, Ferreira was a case about an inquest, so some elements of it are not entirely relevant. But in Ferreira, the P was somebody who had Down syndrome, so were she to be conscious, she would have lacked capacity in that case. But the Court of Appeal decided that she was not in state detention for our purposes, two important reasons. One is that she was not deprived of her liberty because she was being treated for a physical illness, and the same treatment would have been administered to a person who did not have a mental impairment. And the second key reason is that she was free to leave. There was no evidence to suggest that she would have refused, the hospital would have refused a proper request to remove her, and her inability to leave stemmed from her physical illness. So the point really is that she was in ICU, she needed to be intubated, and it was for that practical reason that she could not leave the hospital. If she were to wake or become conscious, obviously she would have to be extubated, but once she became conscious, she would not have been prevented from leaving the hospital. So this wasn't a case where someone was being kept in a locked door facility for reasons of their safety. They were simply incapacitated by their physical illness and therefore unable to leave. So the question asks about PDOC in a care home. If someone were living in a care home and was in a prolonged disorder of consciousness, then the question would be, why are they being detained in the care home? Why are they unable to leave? Are they unable to leave because of their physical condition? If so, I think Ferreira would apply and no authorization would be required. Or if they were to suddenly emerge from their prolonged disorder of consciousness and seek to leave, would they be prevented from doing so? If they would, then they are being deprived of their liberty, and an authorization for that deprivation would be required. So it really depends on the context and the reasons for their detention, if there is a detention. That's my view. I don't know if Sophie wants to add anything to that.
Not in particular. I mean, I think I share your views, and again, it comes back to something that I think we're going to say a lot today, which is it's down to context and sort of the circumstantial, the circumstances that are happening in the background, which I suppose leads quite nicely onto the next question, which is in relation to Section 4 of the Mental Capacity Act. How far does the duty to consult go regarding person interested in their welfare? Would a friend of less than a year's standing need to be consulted, and to what extent? And this is why I say the word sort of context and circumstance is a bit of a buzzword this afternoon, because I think when consulting people under Section 4 and who might be interested in welfare, it does come down to what role those people have in P's life. How involved are they? What's the nature of their relationship with P? And this will speak to the relevance of their opinion in relation to P's best interests and P's own wishes and feelings. I think the length of time someone has known P, it may be relevant to some issues regarding wishes and feelings. So, for example, you know, if someone has said they never wanted to end up in a care home or something like that, you know, if you've only known P for a year, you might not be able to help with that particular issue. But there are certainly circumstances where P could develop a meaningful relationship with someone in a year, and that person could have some, you know, some real authority in terms of what they think is in P's best interests. So when the question that says, you know, would they need to be consulted? I think the best interest assessor would need to sort of step back and think, well, what am I making a best interest decision about? And would this person's views in regards to P's best interest be relevant? Could they help me in making that decision? And if it is someone that's had a meaningful relationship with P for a year, then yes, I see no reason why they wouldn't be consulted and wouldn't help in the consultation as part of that process.
Thanks, Sophie. I think I would agree with that. I think context is everything, and somebody who's only known P for a year might still be their best friend. They might be very close to them. That might have been a very important and significant year. I don't think it's possible to say that because of the length of time, their views are less relevant. I think one might objectively say their evidence may be of greater quality the longer you've known somebody, because as Sophie says, you may have had those conversations with people, but it depends on the context, depends on what that year has been. If that year has been since the events that are relevant, since the brain injury, for example, they might know them very well in the relevant context. So the next question is one that is a little bit more technical, and that is a question about what is our view on the definition of serious medical treatment, particularly in relation to restraint in light of the 2020 guidance from Lord Justice Hayden. Now, to start at the very beginning and try not to give too much of a lecture, Section 5 of the Mental Capacity Act, of course, provides a defence if a person doesn't act having taken reasonable steps to establish capacity, and it does so in their best interests. Now, that will apply to lots of medical treatment, subject, of course, to the limitations in Section 6, which are that if anyone doesn't act that's intended to restrain P, there are further conditions. There has to be necessary and proportionate, essentially, to restrain them. And also subject always, as everything is, to Section 4, capital A, which is that anything that amounts to a deprivation of liberty must be authorised by the court. And that's because Article 5 provides that any deprivation of liberty must be in accordance with the law. So if it involves a deprivation of liberty, then there's always going to need to be an application to the court. Serious medical treatment as a term appears in Section 34, and there all it means is that an IMCA has to be appointed. There is a definition which arises from that section, which is in the IMCA regulations, which is very simply where the decision is either finely balanced or whether treatment has serious consequences, which is not a tremendously helpful in some ways, the definition. So the guidance that was issued by Lord Justice Hayden was to help with the procedure where it's not clear whether it's necessary to bring an application and what one should do if they do want to bring an application. There was a practice direction in the old Court of Protection rules that provided for certain cases where an application must be made, but that doesn't exist anymore. The revised Mental Capacity Act code, which is being drafted, is going to include guidance on this very question. But until that point, this guidance, which is available on Bailey, if you just Google for it, actually, it stands in the interim. What Lord Justice Hayden said was that the fact that certain medical treatments are defined as serious does not determine whether they should be subject to an application. Rather, that indicates the need for special care and attention to the decision-making process surrounding them including the appointment of an IMCA, as I've just said. So even if the treatment is, serious, that doesn't necessarily mean that an application is required. And he went on to say that if all the conditions in section 5 are met and there is agreement, and of course section 6, if there's any need for those to be met too, then there would be no need for an application. There is a non-exhaustive list of the type of cases which might require an application, and they are where the medical issues are finely balanced, where there is a difference in medical opinion, where there is disagreement with those who have an interest in the welfare of P, or where there is a conflict of interest. It goes on to say where any of those matters arise and the decision relates to life-sustaining treatment, an application must be made. And also, in any case which is not about life-sustaining treatment, but which involves interference with ECHR convention rights, then an application should also probably be made. And the examples there were given where sterilisation, because that's obviously interferes with Article 8 rights, where the procedure is for the purpose of donation of organ, bone, marrow, stem cells, tissue, or bodily fluid. Anything involving the covert insertion of a contraceptive device, experimental or innovative treatment to be carried out, and or a case involving significant ethical question in untested or controversial area. So that's the guidance that that Lord Justice Hayden set out. It doesn't really add anything to our understanding of what restraint is. It doesn't really add or alter the definition of serious medical treatment, but what it does provide is quite useful guidance as to where serious medical treatment is being considered when an application to the Court of Protection might be required. Of course, as I said at the outset, anything that involves the deprivation of liberty is always going to require authorization from the court, and it's likely that lots of examples of serious medical treatment will involve deprivation of liberty because of the virtue of the fact that, practically speaking, that's required in order for them to be carried out. So I hope that goes some way to answer the question. Sophie, is there anything that you want to add?
Yeah, no, not really, other than to say, yeah, I don't think the guidance itself alters the definition of serious medical treatment. If we can really say we've got a definition, I think it's quite difficult to pinpoint, what that actually means. But what it does do, as you say, is provide the guidance that almost it takes the light off that definition in some ways by saying just because something counts as serious medical treatment doesn't necessarily mean that it requires an application to the Court of Protection. But equally, there are examples of other times when there is necessity to make that application to the Court of Protection that perhaps wouldn't fall into the ordinary definition of serious medical treatment. And it goes through and lists those items as Richard did before. So I don't think it actually alters the definition per se, but I think it does assist when, practitioners and health bodies and what have you are considering whether and when to make that application to the COP. Going on to the next question then, this one says the question is about remote assessments of mental capacity under the Mental Capacity Act, primarily thinking about assessments for the purpose of Dole's assessments. There's been a recent case, Devon Partnership NHS Trust versus SSHSC, which deals with assessments under the Mental Health Act 1983. And it was followed by some guidance that was published by NHS England. And what that guidance in that case essentially says is for mental health assessments, for assessments under the Mental Health Act, i.e. should someone be detained under the Mental Health Act, then remote assessments aren't good enough. You have to have face-to-face assessments. And the question basically asks, is it the same in the Court of Protection? Is there similar guidance? And would the Court of Protection take that guidance issued in relation to the Mental Capacity Act into consideration when looking at Dole's assessments? There is guidance. It's published by the Department of Health and Social Care. If you just type into Google Department of Health and Social Care COVID-19 guidance DOLS, it should come up sort of as the first Google sort of link, I think. And what that essentially says at the moment, and I say at the moment because since the start of the pandemic and as we've gone up and down through the lockdowns, it has changed. But at the moment, it was last updated on the 12th of January this year. It says that remote techniques should be considered, such as telephone or video calls where appropriate to do so when carrying out DOLS assessments and reviews. What it then goes on to say is that visits can occur if needed, for example, to meet the person's specific communication needs in urgent cases, or if there are concerns about the person's human rights. So it then goes on to say visits by professionals can occur if needed. Decisions around visiting are operational decisions and ultimately for the providers and the managers of individual care homes and hospitals to make. And in a similar vein, it goes on to say that DOLS, best interest assessors and mental health assessors should work collaboratively with hospital and care home staff when making that decision about whether face-to-face contact or remote assessments should be used. What the guidance also importantly says, and I have certainly seen this in some of the cases I've been doing recently, is that where appropriate and relevant, current assessments can be made by taking into account evidence from the previous assessments of that person. Now, I think, if you got this into a section 21A and you relied on an assessment, last year's assessment or whatever, I think you're very much going to be looking for further capacity evidence, when you actually get into the court, and that's something that the OS or ALR or whatever is going to be asking for. However, what that does mean is that your deprivation of liberty, the standard authorizations, aren't going to be prevented because all you can do is access previous assessments. And in appropriate and relevant cases, consideration of those past assessments can be taken into account when filling out the assessments for the updated or the new standard authorizations or what have you. So yes, there is guidance. As I said, it was last updated on the 12th of January, and obviously as of Monday this week, we've had the change in rules where one person can go and visit someone in a care home. Whether that feeds into further guidance in relation to whether they let assessors in, and also with the provision of lateral flow tests coming into force. And I know, for example, in a number of cases I've been doing, I've had sort of experts have started to be allowed to go back in to provide certain treatments or physiotherapy and things like that if they have the lateral flow test, wait half an hour and then can go in. So I think ultimately, you're never going to get better than face-to-face assessments, but given the circumstances we're in, the guidance clearly says remote is okay. And also that, it's not just that it's in this guidance, but that approach was also confirmed as okay, if you like, in the case of BP and Surrey Council, where Lord Justice Hayden confirmed that assessments could be undertaken via Skype or FaceTime in that particular case, given the pandemic. So there is guidance out there, but keep an eye on it because I do think it's going to change in the coming weeks as lockdown eases and goes forward. I was waiting there. The next question's actually mine as well, so I'll carry on. We could have been waiting a while. So the next question that we got in was, when is it appropriate for P to be removed from a placement by police? A bit of context. P lives in a care home. Care home has served notice on P due to his challenging behaviour. P can be intimidating and aggressive towards others. P objects to the placement and does not agree with the alternative accommodation sought. Local authority are concerned that P will be resistive to the move. Therefore, local authority want court order agreeing police will remove P and transport him to new placements. What this sounds like to me is that you're looking for the court to authorise a conveyance plan that allows police assistance if necessary. The court can order that. They can authorise a conveyance plan that may amount to a deprivation of liberty because of restraint that's going to be used and restrictions. But in my experience, and I was speaking about this with Richard earlier, courts are reluctant to do so before other options have been tried or attempted. So I know it's not just use of police, but sort of sedation as well. I've had a number of cases where the court might say, I'd like a more graded approach to conveyance. So, for example, first we'll try, just moving, seeing if P will be okay with that, and will agree to the move. If not, then you might look towards sort of behaviour management and how de-escalation could be used, and de-escalation exercises. If that then doesn't work, that and after multiple attempts, perhaps that's when a court may say, okay, you can then use sedation, or the police can come in and assist with the move. Now, this could be, you could have this graded within one conveyance plan, that you then say you'll try all these things before you use the police or use the sedation. But I've also had cases where judges have said to me, we'll authorize conveyance plan X, which says we'll attempt all the de-escalation and what have you. But if that fails twice, then you can come back before me and I'll consider authorizing sedation or using the police. I think in all these cases, and whenever you're looking at deprivation of liberty or any sort of actions like that, you're always looking for the least restrictive option. And certainly courts are going to want you to have tried that least restrictive option before you bring in things like sedation or the use of police that are probably going to be a lot more traumatic to P. So that would be the case. It's appropriate once you've tried other things, I think, and the court will authorize that, but usually only once those other less traumatic, shall we say, means of conveyance have been attempted.
Thanks, Sophie. Yeah, we talked about this earlier, and I had a case actually this week, or no, last Friday, raising this exact issue, and I was just pulling up the conveyance plan, because in that case there were various options. Now, the first option already included lorazepam, but that's because P in that case already used prescribed PRN, lorazepam, and the judge was therefore prepared to agree that be given the night before, simply to assist. So it's not strictly the same as giving sedation in order to achieve the move, but it's available as the background. And there were, I think, 3 options. The first of which was, behaviour management, try to talk to P. The second of which involved using the staff and using reasonable restraint if required. And then there was an option for involving the police, and the judge in that case was not prepared to authorize the option involving the police unless and until we had tried to do it without involving the police, because even though using some restraint is quite extreme, involving the police is another thing altogether, and the judge wasn't keen to do that without us having tried everything else first. So I think that's right. We have to come up with a plan that allows for different things. And also the other issue in that case was that we arranged it on a day that P's son was able to attend, because it was felt that might assist with making him calmer, that he tended to listen more to what his son would say, and there was a potential that if his son spoke to him about it, he might be happy to go. So I think the answer to the question is, when all else has been tried and failed is the short answer, really. And again, it depends on the individual circumstances, as does everything.
Yeah.
The last question that we have is one that I'm going to start off by addressing. And the question is, where there's an incapacitated adult and it's not possible to ascertain their wishes and feelings, can the next of kin, so 2 parts of this question, can next of kin give authority to not allow contact with other family members, nor request that no information is shared? Well, the short, and it says, I don't think so. The person who asked that question is quite right. Short answer is no. No, first of all, the next of kin is a concept that doesn't really have any relevance in mental capacity. It's a medical legal term, and people, particularly those who are next of kin, will often feel that they should be given particular precedence, and they may be, depending on who they are and their relationship with P. But the fact that they are next of kin doesn't give them any particular power. It certainly doesn't give them any power to place restrictions on contact. If any restriction is going to be placed on a person's contact with other people, then that would have to be proportionate and necessary, because of course, it's likely to be, well, it is going to be an infringement on their Article 8 rights, because we have to remember Article 8 isn't simply the right to family life, which includes family members. It's also a right to a private life, and the right to a private life includes lots of things. It's a very broadly drawn right, but most importantly, it includes the right to decide who we have contact with and who we don't have contact with, the right to control over our sphere of friends. So any restriction on contact would have to be proportionate and necessary. Now, if somebody felt that it was necessary to restrict contact with a particular person for some particular reason, then that is something that those caring for P would want to consider. And if there's good reason to do so, it's something that they might want to do. And that really leads on to the second part of the question, which is where it's essentially the next of kin, so whoever that is, who wishes to prevent contact, but the care home are allowing contact, and the local authority agrees with the care home. So everyone is agreed that P should have contact with this person, apart from one relative who considers themselves next of kin. Does the local authority have to take the matter to the Court of Protection, or should it be down to the party objecting to make the application? Now, my view is that there would be no obligation on the local authority to make an application. Clearly, in an Article 5 case, if no one else makes the application, then there is an obligation because it's imputable to the state. But that's for a very particular reason, because Article 5 includes the right to have your detention challenged in a court. And the state has an obligation to ensure that you get that right. And the way that that trickles through is an obligation on the local authority to make the application. That's AJ and all the other cases. That doesn't apply in Article 8. So if I was acting as a local authority, if we were not putting in place a restriction, and if we were not therefore infringing on the Article 8 rights, I would say that we don't have any obligation to make the application. If somebody else wishes for there to be a restriction, I would say it would be for them to make the application. Again, it's going to be circumstance specific, and if the issue is causing huge issues with the care delivery and the person is refusing to make the application, then I might be tempted to say, let's make the application just so that the issue is dealt with. But I don't think there's an obligation. And the other thing I would say is it sort of depends on why they say there should be no contact. If there's a serious safeguarding issue that's being raised, obviously we would want to be looking at raising a safeguarding concern and investigating that. But that might also, even if we disagreed, I might again be tempted to say, well, let's make the application so that it can be resolved by somebody independent, so i.e. by the court, rather than simply saying, well, we agree with the care home, so that's the end of it. So I think it depends how serious the issue is and whether it's just a family dispute that's something that's going on for years, or whether there's actually a safeguarding issue. So that's what I think on that. Sophie, is there anything you want to add?
No, nothing in particular. I think you've covered everything with that one.
Great. Well, that was all the questions that we have managed to get to today. I'm sorry if we didn't manage to get to yours. If we didn't, then it may either be one about alcohol and capacity, which we're planning to come back to that person on and have a conversation about how we can address that, because it's a very broad topic that might actually require a seminar or actually perhaps a book on its own. Or if it's not that one, then it's one of the others that we didn't manage to get to today. So we will pass it on to those who are doing the next one of these, and hopefully they will be able to deal with it then. But otherwise, thank you all very much for attending. We're not going to take up any more of your precious evening, and we hope and look forward to seeing you all again soon. So I'm going to end the meeting. If you want to ask anything else about what we've discussed, please just drop one of us an email. We'll be happy to talk to you afterwards. Thank you very much.